呢個又係啊！
大家好，聲 OK 嘛？大家到。好，各位市民朋友，大家好，我係今日嘅主持趙麗媛，唔好意思要大家久等下。多謝大家親臨咧今日香港大律師公會有關基本法第23條立法嘅公眾諮詢，公會提交意見書嘅記者會嘅。咁今日出席記者會嘅咧有我哋嘅公會主席資深大律師杜鑑坤、副主席資深大律師毛樂禮、名譽秘書同埋財政嚴永增大律師同埋副名譽秘書黃永海大律師嘅。 咁開始之前咧，我哋而家先俾傳媒朋友影一影相，佢哋會揸住我哋向政府提交嘅意見書俾你哋影相嘅。So now it's photo call time first. While you're taking photo, I'll just do a very quick introduction in English. Good afternoon. Thank you for coming to cover the Hong Kong Bar Association's press conference, stating our position to the Basic Law Article 23 legislation public consultation paper. We have our chairman, Mr. Victor Dawes, SC, and also the vice chairman, Mr. Morley Jose Antonio, SC. The honorary secretary and the treasurer, Mr. Eugene and Martin Wong Wei Koi, our deputy honorary secretary. Now is the photo call time before we get started. They are holding the entire position paper we submitted to the government. Okay, so I think the photo call time now is over. Our chairman will now deliver the opening remark in both Cantonese and English before taking questions. That will be Cantonese first and then English. And before he gets started, our entire version of the position paper will be uploaded to the Hong Kong Bar Association website now. Okay, so chairman, please.
係各位傳媒朋友，大家好。大律師公會喺琴日已經向特區政府提交咗我哋就基本法第23條立法嘅意見書。咁我而家就簡單咁樣介紹一下有關嘅內容。公會同意特區政府喺基本法23條立法底下係有一個憲制責任，政府要自行立法去禁止一啲普遍被認為係對國家安全造成重大威脅嘅罪行。作為香港兩個法律專業團體之一，公會認為就諮詢文件裏邊嘅立法建議提交技術性同埋有建設性嘅建議係重要嘅社會責任，亦都符合公眾利益同埋期望。我特別感謝公會嘅執委會同埋一啲有份參與嘅會員喺過去1個月嘅付出。公會喺意見書裏邊提到，我哋充分認識香港國安法第6條訂明維護國家主權、統一同埋領土完整嘅義務。正如每一個主權國家一樣，維護國家安全嘅關鍵性係不容置疑嘅。喺香港國安法第4同埋第5條裏邊亦都訂明，喺保障國家安全嘅同時，人權應該得到尊重同埋保障，法治原則亦都必須堅持。因此喺憲制一致性嘅原則底下，我哋要確保第23條嘅立法必須與基本法、公民權利同埋政治權利國際公約嘅保障裏邊嘅權利係一致嘅。喺維護國家安全呢個關鍵嘅問題上高，恰當同謹慎咁樣去平衡憲制對基本法、基本人權同埋法治嘅原則嘅保障。呢樣嘢唔單止體現咗尊重法治同埋司法嘅精神，亦對香港同埋國家嘅長遠利益，以至履行基本法第109條有關保持香港作為國際金融中心嘅地位裏邊嘅憲制責任至為重要。我想強調，維護國家安全同埋保障人權喺憲制理念裏邊係相輔相成，缺一不可。兩者亦都係一國兩制行穩致遠嘅基石。因為偵查複雜嘅國安案件喺諮詢文件裏邊加大咗某啲執法嘅權力嘅時候，公會希望當局亦都會考慮對被捕人士嘅權利有相應嘅保障。執法權力同埋權利嘅保障，兩者平衡共存，能夠維持呢個做法，會維持到外界對香港法治嘅信心。公會喺書面意見裏邊參考咗好多其他普通法司法管轄區嘅法例同埋案例，當然唔代表我哋可以喺最後嘅條文裏邊搬字過紙，亦都唔可以淨係考慮其中一條嘅條文而忽略咗整個有關法例嘅安排同埋保障。 我哋亦都認識到每個司法管轄區嘅情況其實都唔一樣。最後點樣去有效同埋合適咁樣就基本法23條立法，最終係要取決於香港獨有嘅情況。喺我哋嘅意見書裏邊，我哋提到有幾個重點。就呢啲方向性嘅重點，我有以下簡單嘅解釋。第一，喺權利同原則方面，正如我頭先所提到，香港國安法第4同埋第5條訂明，尊重同埋保障人權，依法保護基本法同埋國際權利和政治權利公約嘅權利，同埋堅持法治原則，呢個係相當重要。喺定義方面，有關嘅罪行，特別係新增嘅概念同埋罪名，定義一定要清晰。呢個可以避免守法嘅市民或者持份者誤導法網，亦都可以釋除守法嘅市民佢哋一啲嘅憂慮。亦都重要嘅就係清晰嘅定義同埋法律，亦都可以保證確保到真正危害國家安全嘅人被繩之於法。另一方面，就元素同埋定罪方面，構成有關罪行嘅元素同埋定罪標準，亦都一定要清晰。另一方面，喺豁免或者抗辯條例，亦都要提供恰當嘅豁免或者抗辯理由，例如用公眾利益作為答辯理由。至於其他嘅保障，例如性質較嚴重嘅案件，我哋亦都提出係應該要由律政司親自批示。呢一個我哋都覺得係一個非常重要嘅提議。喺我哋嘅報告書裏邊，我哋就每一個章節都有比較詳盡嘅建議。我喺呢個階段我唔一一去解釋啦。現階段我會用英文去再講一次我嘅頭先嘅開場白。Good afternoon, everyone. The Hong Kong Bar Association submitted our position paper regarding the Article 23 legislation to the government yesterday. I will take this opportunity to briefly explain our position. We recognize that under Article 23 of the Basic Law, it imposes an important constitutional obligation on the HKSAR to enact its own laws prohibiting various acts widely recognized as major threats to national security. As one of the two legal professional bodies in Hong Kong, the Bar has the important duty to provide constructive feedback on the legislative proposal. I want to thank members of the Bar Council and other members who volunteered to work on our position paper. There were some long nights for many of us. I want to thank you again for your dedication. In expressing our views in this position paper, we are fully conscious of the duties under Article 6 of the Hong Kong National Security Law to safeguard the sovereignty, unification, and territorial integrity of the People's Republic of China. It is beyond doubt that, as with any sovereign territory, national security is of fundamental and critical importance to Hong Kong and to the nation. The Hong Kong National Security Law also emphasizes and makes plain that under Article 4 and 5, that in safeguarding national security, human rights shall be respected and safeguarded, and the principle of rule of law shall be adhered to. Accordingly, on well-established principles of constitutional coherence, legislation under Article 23 must be consistent with other constitutionally protected rights, such as those in the Basic Law and in ICCPR. We believe it is of vital importance, not only to the rule of law and the administration of justice, but also to the overall long-term best interest of the HKSAR and indeed the nation, and the constitutional duty under Article 109 of the Basic Law in maintaining Hong Kong's status as an international financial center, that a proper and careful balance be struck between the imperatives of national security and the constitutional guarantees of human rights and the rule of law. I want to emphasize that the imperatives of protecting national security and the fundamental rights in Hong Kong can and should be understood and pursued as complementary parts of a single constitutional vision, that of a flourishing one country, two systems. Whilst the consultation paper suggests strengthening certain enforcement powers, the bar hopes that the government will consider safeguarding the rights of the arrested persons correspondingly. The balance coexists of both enforcement power and protection of rights will better maintain the international community's confidence in Hong Kong's rule of law. Now, like the consultation document, our paper contains a number of references to legislation and case law from other jurisdictions. Although the national security arrangement in other jurisdictions are well worthy of consideration as point of reference and comparison, we acknowledge that care must be taken to avoid comparing individual aspects of any given overseas regime in isolation from their particular context. And the circumstances of each jurisdiction would be unique, and that what is effective and appropriate for Hong Kong will ultimately depend on our own individual circumstances. Now, we will of course consider the provisions when the legislation is available, but on matters of general principles, I want to emphasize the following points. One, as I've already mentioned, fundamental rights ought to be specifically acknowledged, such as what was done in Article 4 and 5 of the Hong Kong National Security Law. The definitions in the legislation will have to be precise. Precision is important. It goes without saying that those who are innocent should not be caught inadvertently, but it will also ensure that those who are genuinely guilty are convicted. The threshold and ingredients of the offences should be considered carefully, and matters such as public interest defence and the need for SJ's consent for serious offences should be included. Now, in our report, we have summarized our views on each and every chapter of the consultation document. It is not my intention to repeat them in their entirety, but I am, of course, happy to take questions from members of the press.
好，唔該晒 Victor。我哋而家可以咧用廣東話寫或者用英文提問嘅。咁因為時間比較緊迫啦，希望咧可以多啲記者朋友問啦。最多咧希望唔好多過2條嘅。咁發問之前咧，請你先講出你嘅名啦，同埋所代表嘅傳媒機構。Please consider raising at most 2 questions at a time, so many questions from the floor can be addressed. And you may ask in either Cantonese or in English. Please also state your name and also the media organization you are representing. 好，Alvin。明報。
我有兩個問題啦。第一咧係嗰個 extension of detention 嗰度咧，你哋係咪覺得應該即係如你喺摘要所講咧，應該局限於某一類型嘅罪行，譬如講淨係涉及涉外元素嘅控罪咧？第二咧就係喺個 sedition 嗰個煽動意圖嗰度咧。你哋對呢個刑期或者即係檢控期限嗰度有冇咩睇法咧？同埋喺02、03年嘅時候咧，你哋認為即係啲現行嘅控罪咧已經可以處理當時所謂收集咗嘅煽動叛罪，跟住而家嘅 position 係咪即係再轉咗？
係喺諮詢文件第9章裏邊，的確係列出咗政府係有一個睇法，就係當喺一啲比較複雜嘅案件裏邊，就拘捕同埋羈留可能會有一啲同其他案件唔同嘅安排。我諗我哋嘅立場就係第一，正如我喺開場白所講，有關被告人嘅權利當然係要獲得保障。我哋同意喺某些案件裏邊，特別係性質比較嚴重嘅案件，的確係可能會有需要去就現行嘅安排作出一啲嘅修改，但係最緊要嘅呢一方面，我諗最緊要嘅地方都係我哋要睇到成個機制裏邊有關警方嘅權力同被告人嘅權利得到一個適當嘅平衡。就呢一方面，我諗係我哋都見到喺第9章裏邊其實參考咗有一關英國嘅做法。 而我哋喺第9章嘅文件裏面都譯出咗，其實考慮外國嘅條例嘅時候，有關方面都應該考慮到當中相關嘅保障。所以喺呢一方面，我諗有條例草案嘅時候，我哋會可以再作出一啲詳細啲嘅研究或者探討。至於就煽動叛亂罪行，嗱喺23條底下，我哋的確係有義務就煽動叛亂自行立法。喺呢個前提之下，公會係原則上支持政府履行憲制責任，就煽動叛亂立法嘅。嗱，我哋當然留意到喺其他司法管轄區喺咁多年裏邊，係的確有啲唔同嘅做法，有啲可能將罪行縮小，或者有啲廢除有關嘅罪行。咁喺呢一方面，我哋都提出咗一系列嘅建議，亦都可以考慮外國嘅做法。當然到最後，我哋香港點去處理呢一個問題，就有關方面亦都要考慮翻我哋香港嘅情況去處理。咁當亦都喺有關法例條文出台之後，我哋都會繼續去研究呢一方面嘅問題。Alvin， 你咪有第3條問題，唔好意思。
就住 sedition 嗰個刑期同埋檢控期限。
就住刑期同檢控期限，我諗我哋而家係冇一個確定嘅睇法。我哋都係想睇咗有關嘅條文草案出台嘅時候，我哋就會再提一啲嘅建議。
下一條，Chen 老師。
你好，Chen 老師陳朗升。想兩個問題。第一個問題就係嗰個煽動叛亂嘅煽動意圖嘅罪行啦，因為你哋都見到話公會都理解係有機會影響啲影響合法表達同埋真實唔同意見嘅權利。咁最尾第3段你都提到，其實公會都係覺得要去到意圖推翻或者嚴重危害國家安全嘅即係煽動意圖，佢哋都覺得係即係應該係要去規範啦。咁但係大家都知，而家喺現行法例裏邊咧，嗰啲引起仇恨啊、引起叛逆啊、唔中意啊、嗰啲都係當係煽動嘅，係咪即係可以理解為公會認為即係嗰啲引起憎恨啊、憎恨政府啊嗰啲係即係會係過於寬闊咧？咁呢個係第一條問題嘅第一部分，同埋大家都知嗰個條文源自於係大家對即係女王啊或者英皇嘅即係憎恨啊各樣嘢啦。咁其實英皇大家都知喺政治上面係一個虛君啦，係咪可以同一個即係有行政權、立法權嘅政府去比擬咧？咁呢個係第一個問題。第二個問題就係見到嗰個釋囚嗰度，即係話consultation paper 有講到咧，就係話要去再考慮佢哋係咪提早釋放啦。咁我見到你哋即係呢個摘要有提到話係咪即係公會希望政府釐清係咪有需要提前釋放呢個罪人士，或者有進一步規定？可唔可以理解其實公會覺得喺現行嘅做法裏面已經足夠啦，唔需要喺提早釋放呢個問題上面即係有更加多嘅做法咧？
多謝你嘅問題。就喺煽動意圖罪行呢一方面，我哋同意政府嘅講法，就係其實現有嘅法例咧，的確係有修改嘅空間嘅。正如你頭先條問題所講，而家仲講緊女王或者相關嘅字眼。咁喺其他嘅司法管轄區裏邊，的確係有唔同嘅做法。你見到有啲地方可能縮小咗罪行嘅範疇，或者有啲地方可能廢除咗啦。就呢一方面有關注，我哋可以理解。我哋認為喺具體嘅法律條文上高作出適切嘅調整，去回應社會上高呢啲嘅聲音。我哋相信特區政府係會考慮嘅。而喺定義上高，我哋希望可以做到係盡量清晰，去確保基本嘅權利係可以受到保障。詳細我哋都分析咗好多唔同地方嘅做法，喺我哋嘅詳細嘅公會嘅意見書裏邊，亦都提到。至於第2條問題，就係關於釋囚嗰個問題，我哋的確喺第9章裏邊提到就話，其實現行嘅法例都係有機制可以去考慮有啲咩情況係可以盡早釋放嘅。咁如果當局係就第23條嘅案件裏邊，想有一啲唔同嘅做法，我哋相信進一步嘅解説可能係必須嘅。
好，商台。
邊位係商台？港台。
港台 ，sorry， 唔好意思，港台。
Hi, Mr. Dawes. I'm Damon Pang from RTHK. Two questions. One is on why the bar is proposing to the government to narrow down the definition of seditious intention. That's number one. Number two is also on, your proposal about the release of convicted persons. Can you explain that? Are you saying that what the government is proposing to further issuing conditions for them to not be released early? Is the bar thinking that that's not something that the Hong Kong needs? Thank you.
I believe I have answered the first questions, and the details are in our consultation paper. But if I can just repeat that in English, I think there are really different ways of handling this, and there are different situations in different jurisdictions. What we have done is to set them out in some detail and suggested a number of different ways forward which can be considered. That's the first question. Insofar as the second question is concerned, what we are suggesting is that under the existing mechanism, there are also established ways of handling the early release and the sort of conditions involved, and which has already provided a lot of flexibility. And if there are going to be changes, what we are hoping the government would do is to try to elaborate the needs and the rationale, and we can engage in a more detailed debate then, because in that regard, as you will appreciate in the consultation document, they have made the suggestions, but that has not received too much of an attention, and we're really urging the government to try to provide more elaboration.
嗰位戴眼鏡嗰位女士，黃色。
narrowing down.
你好，信報記者，我都係想問煽動意圖嗰度啊，見到咧大律師公會就話考慮要將煽動意圖嘅定義收窄，加入呢個煽動暴力啦。但係睇翻諮詢文件咧，原來政府係有建議咧，係提出到煽動係唔一定同時煽惑他人使用暴力或者係騷擾擾亂公眾秩序嘅。想問下大律師公會點解有呢個收窄嘅定義嘅提出咧？同埋咧，即係見到英國樞密院去年都有裁定過啦，煽動意圖咧係煽暴嘅意圖咧係煽動定罪嘅隱含必要條件嘅。咁如果最終23條嘅立法都未必需要有呢個煽暴意圖嘅時候，會唔會違反咗呢個樞密院，即係有啲違背咗呢個樞密院嘅裁決咧？同埋第二就想問下減省程序嗰度嘅，因為見到政府係提出咧就要完善嗰個訴訟程序啦，減省法庭嘅一啲程序嘅。咁其實局長之後司局長之後有提出就有兩個例子，例如咧係嗰啲翻譯嘅文件咧係唔需要有中英兩個翻譯啦，又或者咧甚至保局局長咧提出嗰個司法保釋覆核嗰個法律權利咧，即係會唔會有機會都會冇咧？即係可唔可以大律師公會可唔可以講下點解你哋認為其實減省程序方面咧，其實大部分呢啲程序都係保護緊疑犯嘅權利嘅，係唔應該減省咧？唔該。
我諗兩點啦，就煽動意圖嗰度，你睇到其實我哋都講得好清楚，我哋嘅立場係每笪地方都有唔同嘅做法，而的確有啲地方係縮窄咗有關嘅範圍。譬如我哋提到喺譬如我哋如果你哋睇到我哋已經輸喺86.9.4段裏邊，其實我哋提到可能譬如新加坡咁，佢就話係會有可能係有暴力啦，或者違法啦，或者一啲擾亂安寧嘅行為。我哋喺報告裏邊提到有好多唔同嘅做法係俾政府可以去考慮。至於你頭先提到樞密院2023年嗰一宗案件，我諗相信嗰個都被廣泛報導，政府亦都當然會考慮有關嘅案件。嗰一單當然對我哋香港法庭嚟講唔係一單有約束力嘅案件，而我覺得到最後政府都要考慮翻我哋香港嘅情況，去作出一個決定。而有關嘅決定，我相信佢哋亦都會作出充分嘅解釋嘅。至於減省程序嗰個問題，呢一個的確係我哋有好多會員會關心嘅問題啦。因為我哋大律師係出庭律師，我哋會處理比較多前線嘅法律工作。而你問我係咪唔可以減省，我哋絕對立場就絕對唔係話一刀切唔可以。因為譬如頭先呢位朋友提到嘅中英文需唔需要一定翻譯？有啲案件而家我哋留意到，可能真係有一個法例上嗰個規定要係有中英文嘅文件，但係可能因為而家有啲案件裏邊，大家都睇到成個法庭其實我哋都係識睇中文或者要用中文審訊。喺嗰啲時候係咪有空間去 減省有關嘅程序咧。嗱，而呢一個對於被告人嘅權利，我覺得都係會彰顯到嘅。你唔需要去翻譯嗰啲文件，你可以做快啲。特別對於一啲被羈留人士嚟講，快啲能夠去審訊係相當之重要嘅。至於其他嘅機制係咪應該或者可以減省咧？我覺得好睇個別嘅情況，絕對唔係話一定可以或者一定唔可以。而有時減省咗，我哋都覺得係可能會令到被告人嘅權利更加受到保障嘅。當然唔係話全部嘢都可以減啦，因為有一啲嘅機制其實亦都係我哋保障被告人嘅權益嘅。
Okay, next question, SCMP.
Oh.
I'm from the SCMP. Just want to know that about unlawful drilling, you said it will be in line with other countries' similar offense if it has been amended according to the recommendation. Could you elaborate on that? Because we have scholars concerned that it may catch Chinese citizens outside joining another country's military force, and also about external interference. You have a suggestion that listed in this summary, but could you elaborate on how it should be narrow, because there are concerns from other governments. We have learned today that it may curb the legitimate diplomatic activities. What's the Bar Association assessment on this external interference potential impact on this legitimate activities?
Insofar as unlawful drilling is concerned, you will note from our position paper that a number of exceptions have also been also exist under the existing Section 18 of our Crimes Ordinance, such as the following persons will not fall foul of the relevant legislation: public officers, non-Chinese citizens with foreign nationality to serve in an armed force, and persons who participate in drills in which the PRC is participating. So I think we believe that there are sufficient safeguards, and if there are further concerns that will be elaborated when the bill is out, we will definitely look into it further. Now, insofar as external interference is concerned, of course it cannot have the inadvertent effect, and I do not believe that it is the intention of the government to curb or to restrict diplomatic relations. For example, the usual interactions with consulate generals in Hong Kong. Anything, of course, to do with external interference may result in such discussions, but so long as the provisions are clear, the definitions are clear, I don't believe that that is the intention, and the risk can actually be minimized. Of course, in this regard, interactions between our government, consultation or discussions with foreign CGs will of course be helpful.
綠色衫嗰位。
呢個雜誌社㗎。首先想問翻國家機密嗰度啦，即係見到工會position 都有寫話建議國家機密嘅 definition 要同翻即係內地嗰個保守國家秘密法係保持一致，但係見到譬如政府諮詢文件個寫法，即係譬如定義嗰度都同保守國家秘密法係有啲唔同，即係譬如最後嗰一條講到當乎中央同香港特區政府關係呢邊啦，同埋即係譬如而家草案即係諮詢文件嗰度寫話喺冇合法嘅權限底下披露就有可能危害國家安全啦，都同即係保守秘密法嘅寫法係有啲唔同嘅時候，即係想問下工會個 position 係點咧？即係係咪覺得所有相關嘅條文都應該要同國家秘密法保持一致咧？同埋都會唔會擔心即係一致嘅時候都俾外界個觀感喺香港個法例條文都同內地比較似咧？另外都想問啦，因為喺02年工會都有一篇比較長嘅意見書啦，當時睇翻啲意見都相對比較進取，即係可能建議翻引力叛國呢啲定義可以刪除成條條文啦，但係今次相對當年嘅意見書比較保守，可唔可以講多少少即係話俾公眾聽點解即係睇落去今次嗰個 gesture 好似保守啲咧？有冇啲咩原因或者你哋睇到嘅情況係點解會咁令到你哋有啲咩睇法咧？
就定義嗰個問題，國家機密嗰度我哋講得好清楚，其實有一致性，冇矛盾，呢個係必須嘅，即係喺香港特別行政區，如果有一個同內地有矛盾嘅定義， 我諗大家都可以估計到會有好多問題。我哋亦都係話就呢一方面，其實有好多譬如商業活動、社會嘅活動、經濟活動，或者有關於一啲科技嘅發展，其實有清晰嘅指引，呢個都係相當必須嘅。咁所以我哋認同個方向性就係，因為我哋而家都係處理緊一啲方向性嘅文件。我諗冇矛盾，同埋有一個一致性嘅，我哋可以見到點解需要咁做，而我哋亦都係同意嘅。但係就細節方面點樣去避免到你頭先講嘅問題呢？我相信喺個條文上高預寫得好清晰啦。至於我哋嘅立場，大家見到我哋嘅諮詢文件其實係相當詳盡，同埋就每一個建議，我哋都考慮咗好多外國唔同嘅做法，亦都我哋覺得我哋係履行咗我哋嘅責任，係考慮到而家香港嘅情況，考慮到法律嘅發展，提出咗最有建設性嘅建議，供特區政府考慮嘅。咁所以就呢一方面嚟講，我哋覺得工會係盡力咁表達咗我哋應該表達嘅立場。
呢位藍色衫。
Timothy Lee from TVB News. So regarding the bar's position on individuals other than journalists having the right to invoke the public interest defense in cases involving theft of state secrets, how does the bar intend to extend this right, and on what grounds, and are all individuals allowed to invoke this right, and what determines the case severity and threshold? And the second question is just to add, perhaps the bar can share more details about its consideration to narrow down the definition of seditious intention. Thank you.
Yeah. Insofar as your first question is concerned, Actually, why don't you repeat your questions? I didn't quite catch the first part. The questions are too long.
All right, sorry. So it's about the bar's position on individuals besides journalists having the
I
right
see.
to vote.
Now, insofar as the public interest defense is concerned, many of you would have noted that I've actually expressed a preliminary review a few weeks ago regarding this aspect, and we've indicated quite early on that it is certainly worth considering. In respect of whether it should only cover journalists or everybody, since the potential that anyone can be caught by the proposed offense, we believe that the defense should not be restricted to journalists. In respect of your question about threshold and individual circumstances, we have also expressed the view that, of course, the threshold can't be low because at the end of the day, it can be abused. As to individual circumstances in each and every case, we'll just have to look at that when that arises. So long as the legislation is clear and the threshold is clear, it will be interpreted by our common law courts, and the court will also develop its own jurisprudence as and when the situation arises. I believe your second question has been asked and answered.
嗰位藍色衫
Two questions from AFP. First, on the prolonged detention without charge, the Bar Association says there must be strict application and detention time limits. What do you mean exactly by that? Is there going to be, or should there be a hard cap on the maximum detention time? You can never go above a certain detention time. And when you say the detained person must have an opportunity to make representation, do you mean make representation in front of a judge? My second question is about the legal profession more broadly, because barristers from overseas can come to Hong Kong for cases, and in some cases we see that there are defendants who have overseas lawyers teams who are quite vocal. So do you, for opposition activists, they have retained overseas lawyers who are quite vocal. So would that have any overlap with the external interference or external forces, limb, and does that actually affect the international character of how the bar operates?
In respect of your first question, we must look at the package as a whole. So in other words, I can't tell you whether 36 or 37 hours of detention is more appropriate. I'm sure the government will come up with a package balancing the rights of the detainee and the need for further investigations. I mean, that is absolutely essential. And I don't get from the consultation documents that aspect is ignored. So in other words, when we say that it is of course essential for a defendant to be able to make representation, I mean the preference is of course when you are detained up to a particular period of time, one has to be brought before the court. Now there are of course circumstances that may justify, and I say may, a longer period of detention, but that will have to be carefully balanced. Now in respect of your second question, Hong Kong is an international city. There are foreigners practicing in Hong Kong. I mean, many of them, you can't call them foreigners because they have made Hong Kong their homes. There are also overseas lawyers practicing in Hong Kong at any given time. I mean, we admit a number of London Council, for example, to conduct civil and criminal cases in our High Court every year. There are also overseas lawyers, for example, practicing arbitration. That doesn't require permission from the Bar Council or the court. They are part of our thriving arbitration community. Now, as to the point that you mentioned about activists, now the barrister profession is a legal profession. Those who practice in our courts are here to argue cases for their clients instead of being here as an activist. One must carefully identify one's role in discharging one's duties. So the two should not be confused.
As the chairman has an important engagement afterwards, so the last questions from our gentleman here. 呢位陸先生，最後一條問題啦，唔好意思。
佢先問過有冇第二？哦，係先。
首先咧，想問翻即係關於人力叛國罪方面啦，即係03年政府都取消咗呢個罪行，其中一個原因係即係當年大律師公會都係反對嘅，當年意見書就話即係普通人係好難去定義叛國啦，擔心嗰個運作上有困難。即係現屆嘅即係工會咧，究竟對於嗰個人力叛國罪嘅立場係點咧？係咪即係唔再反對個人力叛國？即係係咪當年即係提到嘅一啲疑慮喺今屆就會認為即係不再存在咧？咁第二就係關於擴大執法權嗰方面啦，即係工會嘅立場係咪即係都覺得即係可以即係容許擴大執法權，即係例如即係延長羈留時間方面，係咪即係跟到英國嘅嗰個做法咧，就即係滿足到保障人權嘅條件咧？同埋即係特別提到係會特別即係禁止見某一啲律師啦，會唔會擔心即係工會作為一個律師團體，會唔會擔心話呢個會即係用嚟針對某一啲嘅律師咧？點解？
首先第一條問題人力叛國罪，如果你睇翻我哋嘅意見書第22頁喺網上都大家都睇到㗎啦。其實我哋考慮咗美國、澳洲、新西蘭、加拿大同埋新加坡嘅有關條例。其實你見到喺唔同嘅司法管轄區喺今時今日都係有相關嘅罪行嘅，所以你見到我哋建議裏邊，我哋都係提到當有關嘅罰則同埋有關嘅條例係清晰嘅時候，我哋見唔到點解我哋香港作為一個司法管轄區就可以冇呢一個罪行。至於你講緊應該係第9章有關權利嘅保障，呢個當然作為大律師公會，我哋有好多會員係關注呢一方面嘅問題，可能係我諗主要原因就係我哋嘅會員做好多前線嘅法律工作，出庭啦、申請擔保啦，甚至乎去警局處理保釋嘅情況。我諗就呢一方面，我哋可以講嘅就係處理國家安全嘅案件，喺其他嘅司法管轄區，亦都的確有同佢處理普通案件唔同嘅做法。我哋唔可以話一刀切唔去改呢一樣嘢係合適嘅，因為的確有複雜嘅國家安全案件，可能警方嘅權力係要比普通案件較為多。但係我哋亦都多次強調，應該作出適當嘅平衡，平衡警方嘅執法權同埋平衡被告人嘅權利。咁呢一個係至為重要，我哋亦都喺之前嘅篇幅同埋喺我哋意見書裏邊多次強調。
好多謝大家今日出席嘅記者招待會。Thank you for attending today's press conference. Thank you very much.
Thank you.
英國做法就足夠。